Hey guys, it's Rainey Romero with the lovely law firm. You are watching the Carolina Justice Report, and I'm joined with attorneys Justin Lovely and John Paul Simkovich, and today I'm learning all about what litigation is. So today we're learning all about litigation, which is something I know nothing about, so this will be perfect for me. So John Paul, you can start us off. So you are in the Charleston office, right?
Correct, yep.
So I hear that you're like the litigation man, is that right?
I don't know if you'd go that far, but I definitely do handle a lot of litigation. And so what that means is, you have an accident, you call us. Litigation is once we actually file a lawsuit, and we get the court involved. If we can get something worked out and resolved and the client's needs are met, then we don't need to file a lawsuit. But if we do, that's when the litigation process starts and things start to ramp up.
So this may seem like a silly question, but even filing a lawsuit, what does that mean?
Essentially, it means that Justin or myself or another attorney in the office will draft what's called a complaint, and what that is just stating the facts, what injuries you sustained and why we contend the other party is responsible for the injuries you sustained, and we file that with the court, pay a hefty sum of $150 or $180 now, I have to check, and the court will file that, a case number will be assigned, and then we need to serve that document on the wrongful party.
So that official complaint is the lawsuit?
That is, correct.
So then it goes to litigation from there?
Goes to litigation. The defendant, the party that we're claiming is at fault, has 30 days to respond to it. They respond to it, they file what's called an answer. It's they basically admit or deny any of our allegations, and then we engage into what's called the discovery process.
Wow, this is in depth. So just to backtrack a little bit, because I'm trying to process it all. So the litigation portion of it, what does litigation do? Why would you need to do litigation?
Well, sure. So, if a client comes to our office, we're going to find out what's going on. There's obviously a reason they reached out to us. Once we get all the information we need, we'll either contact the at-fault party or their insurance carrier, normally their insurance carrier. And if we can work out a resolution, great, but a lot of times insurance carriers are not willing to pay. They'll take unreasonable positions, and the only reason we can get their attention is to file a lawsuit, and lawsuit's the enforcement power. If we go to trial and get a jury verdict, then they're bound to pay the compensation that we win and the client deserves.
So, Justin, does this only happen for car accidents, or is this kind of for any?
Well, it's really any case, and you've heard me talk before. How do we hold somebody's feet to the fire? Obviously, nobody wants to go to court. Everybody wants to try to settle these things pre-suit. But if we're not going to get a full and fair settlement for our clients, then we have to commence the litigation process. So as JP said, we're going to file the complaint. They're going to file their answer. But it's for any kind of negligence action that we handle, whether it's a slip and fall, if it's a dog bite case, or a car wreck. Car wrecks are the majority of our litigation practice.
Okay. So take me through the steps of the litigation. How does that happen, the procedure for it?
Sure. Well, the first thing that we discussed is filing that complaint, starting the lawsuit, getting the claim or the case number. The clerk of court will start basically a file for the case at the local courthouse. They'll file the answer within 30 days. Sometimes they get extensions, but it should be 30 days. And then we engage in what's the discovery process. And the discovery process is finding out all the information that the defense or the defendant is going to use to try and argue why they aren't liable. Now, the plaintiff, the party that's been wronged, they have the same duty. There's no surprises. Once we get to trial, both sides should know everything there is to know about the facts surrounding the case. So discovery process is just an exchange of information.
Gotcha. So litigation happens when it's going to go to court?
Litigation is just the overall term used for getting the court's involvement.
Gotcha.
If we're going to be using the court to assist us in deciding who is wrong and who is right, that would be the litigation process. The filing of the complaint, the answer, the discovery, then actually adjudicating it at trial.
Okay. Justin, what does it mean to have a subpoena?
So there's certain documents, there might be other parties, other documents, other anything that we might need to prove our case. And the laws and the rules of civil procedure give us power as officers of the court to get that information. And so what we would do is we go through the process of issuing a subpoena. We let the other side know this is what we're looking for. And usually that's, are we subpoenaing medical records? Are we subpoenaing video surveillance maybe, or any kind of other document evidence? And that then that forces it's an order of the court to basically provide that information to us, which we will then look through and hopefully use it to prove our case.
Okay. And then what about with the mediation? What is the mediation used for?
So let me answer that. So it's a long process once we start litigating the case. So the first thing we're going to do, as JP said, is we have to go through the written discovery process, and that gives us clues and information of what facts do we need and what pieces of information are we going to need to start depositions. Okay, we'll do depositions. That's where we are orally putting people under oath and getting their side of the story, getting their facts, whatever that may be.
And that's done like in the office or something?
It could be in office. A lot of it's virtual now through Zoom.
Okay.
That's the one good thing about COVID. It's instead of having to come and get everybody scheduled to come to a location, we're able to do it in the comfort of their home, and we're in the office, and we can do it all virtually. So that's great. But we get those done, and then once we've gone through everything, we say, hey, we've got enough to prove the case. We're ready for trial. We are a mandatory mediation county. Well, the whole state now is mandatory mediation. So, and what that means is that's an opportunity for us to meet. The defense will be there. We usually pick a third-party neutral. It's usually a retired judge or an older lawyer, a lot of experience on both the defense and plaintiff side. And we'll meet with them, and this could be virtual too as well with Zoom. But usually we'll go to a neutral site. We'll put on a presentation. They'll put on a presentation. We never show all our hands, because we save some things for trial if we have to try it. But usually when we get to that point, we're at the point where we know how strong our case is.
Right.
We kind of know a settlement range. We're going to meet with the client, and usually we get a good resolution at that point in time. And most of our cases, that we have to file and have to litigate, will get resolved at the mediation.
Okay. I feel like a lot of times, the general public only thinks of mediation for like divorce type of situations, right? That's what I envision in my head. So really you can do mediation for all of these different types of cases.
Yeah, and sometimes depending on the facts, every case is different. So we might want to do an early mediation if we think it'll benefit the client. Sometimes we do pre-suit mediations, but most of the time, once a case gets into lit, it's going to follow that standard process of getting the written discovery done, getting the deposition scheduled, and then, figuring out what else we need. If any subpoenas have to come in, we have to wait on more documents or more evidence. And then once we know it's ripe for mediation, where we're going to actually make a meaningful effort to get it settled, because clients want finality. They want it over with. They don't want to go to court. They don't want to wait a year. And sometimes it takes a year or two to get these things done. So we're doing everything that a lovely law firm can to work these things up from the day we file that complaint to get to that point of mediation, to get the money in the client's pocket as fast as possible.
So it may not even need to go to trial after that.
Well, that's the goal if we can resolve it. But I mean, there's instances where they're going to lowball us, and it's not full and fair. And clients may even tell us, "I want to settle it," and we say, "Look, we cannot take this offer for this case."
Yeah,
and every case is different. And if that's the case, we'll take it to trial if we have to.
Okay. So tell me, if it does go to trial, what is the roster system?
I'll take that one. So the roster. And this is something that's kind of unique, because I grew up in the Tennessee court system, and then I came down here to South Carolina. But this is how, at least in the state courts, we're going to be set with a roster. And what a roster meaning is you file a complaint. Let's say we file a complaint today. Okay, well, we're not going to get on that roster. And what the roster is what's going to trial that week. So we're not going to get on that roster for a year and a half to 2 years if we filed it today.
Wow. And
that's pushing it hard. And now the court system has done a good job of moving cases since the COVID backlog. We're still a year and a half out from trial. Crazy. So what that means is they'll send a list of cases, and it might be 40 cases on the list. But just because you're number 40, you might go to trial because dockets fall apart, cases get settled. But they won't give you a date certain. Sometimes they will. You have to file a motion, try to get a date certain. But the roster system is essentially, hey, you're on the roster now, and you might be number 1, you might be number 40. It just depends on what's on that county. And we meet, and the judge is basically trying to figure out who's going to trial this week. How long is it going to take? Is it a 1-day trial? Is it a 3-day trial? Is it a 2-week trial? And he'll go down there and he fills the trial courts up. So he or she, depending on what judge we get. So they'll fill the trial rosters up, and then the trial dates for that week or that 2 weeks, whatever the term of court is. And then they do that every term of court. And that's basically, it's like a rolling cycle. So even though you're 40 on it, this roster, maybe next roster, you're number 3 or number 4.
Okay.
Well, you got to be ready to go to trial.
Right. So you can't wait thinking like, oh, I got a year to get more evidence and stuff.
We start preparing for trial when we file that complaint.
Okay.
Okay. You can't wait.
Right.
Because if you wait, you're scrambling. You won't have a complete case file. And we have the burden of proof as plaintiffs. We have to prove the case. So we can't be messing around, delaying. So JP and I and Sarah, we're always rocking it, pushing things as fast as we can.
Well, let me ask you this. So, with going to trial and getting a trial date, do the courts ever push certain cases up depending on what they're about, or do you just file in line?
Well, it's not really what it's about. I mean, but if you have a complex case and, they got a certain judge and everybody's in town and they need to try that case, that's something that would be discussed at that roster meeting.
Gotcha.
If a docket falls apart and we got 2 soft tissue cases he can try in one day, a judge is going to say, hey, you're going Tuesday, you're going Thursday. Because we also don't want to waste the jury's time, right?
Sure.
This jury pool's coming from, they're pulling people from Horry and Georgetown counties, and we got to get a jury pick, don't want to waste their time. If they're going to be around, they got to be ready to be set and move the court system along.
Okay.
And if things don't go to trial, it just keeps the backlog going and going and going.
Man, that's crazy. So you really got to be patient with stuff like this.
We don't like to be patient.
Right.
We want to push it.
Right.
But sometimes you do need to be patient.
Yeah. Well, from the court side,
Yeah.
and then you have to be patient. So, I know that you can sit on that roster for a year or more, but what is the process timeline-wise from start to finish, from even just filing that first, what was it called? Claimant?
The complaint.
Complaint.
So when the earliest you could get a trial date would be 1 year from filing that complaint. That's by law, so we can't ever have a trial sooner than a year.
Okay.
Now, because of, like Justin mentioned, the court system's overburdened. I'm sure everyone's heard about that. You throw on COVID when the court system was closed for a year to 16 months or whatever it was. All those cases didn't get tried, so now they're getting tried now. You have folks in criminal, waiting trial. The same judge that does a car accident case is overseeing a criminal case. So,
wow.
A lot of these criminal folks are getting precedence because they're waiting for their trial date. So we're kind of at the mercy of the court. Once you are on a roster, like Justin alluded to, they're going to set basically 40 cases saying you're up for trial that week. Now, it's in chronological order, 1 through 40. So if you're 40, you probably won't go to trial that week, but you don't know, like you said, if everyone settles. Right. So you have to be prepared. You have to have your witnesses prepared. And you certainly need to have all your discovery done. And, when we were talking about discovery, written discovery is really an exchange of documents. Interrogatories are an exchange of information. It's questions that each party has to answer. And we can come up with whatever questions we want. They have to be relevant, and the other side has to answer them. They're going to send us the same question, similar questions probably, and we're going to have to answer them. Now, one of the biggest holdups that we're experiencing is defense attorneys or, anyone on the other side that we're going against not responding to the discovery questions that we need. Technically, the rules allow for 30 days. Once we send them to them, they have 30 days to prepare their answers and send them back to us. But all too often, 30 days passes, 60 days passes, 90 days pass. We don't,
wow.
And we don't have answers. Now, we'll never let it get to that 90-day mark, but the only recourse we have is first we're going to just reach out and ask the other side, hey, what's the holdup? When are you going to get these to us? And when we don't get a response that we feel is reasonable, we're going to have to take matters into our own hands and file a motion with the court. And that's called a motion to compel. And what that means is we're asking the judge to order the other side to provide us the answers that they're already legally obligated to provide us, but they kind of need a kick in the pants from the judge to actually do it. And a lot of times just filing that motion, the other side doesn't want to have to go in front of a judge and explain why they couldn't respond to it. Sometimes we do have to go in front of the judge and argue. Maybe they do respond, but they do it the night before. Right. And, our clients have been waiting patiently for 6 months, and the defense is just delaying, wanting them to, just roll over and accept an amount of money that isn't fair and reasonable. And in that case, we're going to be asking for the costs or the fees and anything else that are associated in moving forward in the delay. So motion compels, we file them. Don't like to, but sometimes it's a necessary evil. Yeah.
Does that happen pretty frequently where they kind of delay responding for a while?
Oh, all too frequently.
Really?
Yeah.
We're seeing it more and more. It's a game they play. Because remember this, and I've talked about this. What's their job? deny, delay, devalue.
Right.
That's what they're doing. Even when it gets into litigation, I mean, they're playing the same game. So
Yeah.
we have to control what we can control, and that's
Sure.
why we push the issue, get those motions to compel filed, and just do what we got to do for the client to get the case worked up.
Sure. So what is the client's responsibility in all of this?
Well, the main thing is their deposition. And JP or I will prep the client. We'll sit down with you before your deposition, and that's just where the defense is going to get a chance to ask them any kind of question that they think will be relevant to defend that case. And you're going to be sworn under oath, and we'll prep you. And it usually takes a couple hours. If it's a more complex case, it might take a little longer, but that's it. Once you get the deposition done, we're doing all the heavy lifting on the back end. Of course, the client needs to, if the medical condition changes or you got any other kind of element of damages that changes since we filed the lawsuit that we don't know of, constant communication is key to get maximum settlement value when we get this thing to the finish line.
Sure, sure. So, going back to mediation, who pays the mediator for that?
Well, typically,
And the mediator, is that like the judge or whoever that third party is, or who's the mediator?
so the mediator's a neutral third party.
Right, okay.
Normally, every time it's going to be a licensed attorney, and both parties have to agree on who that mediator is going to be, and typically it's going to be a very experienced attorney that's probably tried very similar cases. So if it's a car accident case we're mediating, that mediator's probably been an attorney on either side and tried a lot of car accident cases, understands how a jury's going to evaluate it and view it and that sort of thing. And they charge hourly. Typically we split the cost between our clients and the defendants.
Gotcha.
Sometimes we can negotiate, maybe the defense is going to pay for all of it. It's kind of case by case. Typically it's split, but that mediation process, it sounds kind of silly to have a neutral third party exchange money back and forth, but if you trust the process, it really does work. The mediator can look at the insurance company and say, hey guys, I'm talking to the injured person over here. The jury's going to like him or her. The accident is high impact accident. They're injured. Their medical bills support it. What are y'all doing? Why are y'all fooling around? You're going to lose that trial. Let's resolve this, make everyone happy. And the same mediator might come over to Justin or I and our client and say, y'all are too in depth. You're not viewing this objectively. Here are the flaws in your case. Maybe you need to move down from your demand. But ultimately, both parties are going to leave unhappy. The insurance company's going to pay too much. Our clients, we always want the maximum value. So if we get anything less than that, we're going to be dissatisfied too. But that's kind of the nature of a good agreement. And the mediator really is useful. And that's why it's mandatory everywhere in South Carolina before you get a trial date.
That's interesting. It's a little bit of like a poker game in a way.
Yeah, it is.
Yeah, it's definitely a game, and there's definitely an art to it. And
Yeah.
we do these all the time. So we have certain mediators that we use for certain cases. The defense has certain mediators they want to use for certain cases. We know that we need to keep some things in pocket, not really play all our cards to the mediator.
Sure.
Because again, they're going from room to room. But hopefully at the end, as JP said, if you trust the process, we're going to get it to the finish line. You'll get your check.
Yeah. Man, lots of stuff. That was really informative.
Yeah, usually this is
thank you.
a very dry
Yeah.
topic, not what we're used to on the Carolina Justice Report, but it needs to be out there because we get a lot of questions about this, and people don't understand this.
Well, I definitely didn't know what it was.
And the time aspect of it. You just got to be very, very patient on us. You mentioned that earlier, but we will understand it's going to take a while, but we will push it as hard as we can possibly push it.
We're going to plan every case like we're going to go to trial, because the last thing you want is to be, maybe a year does pass and we get on that trial roster and we don't have all our ducks in a row. We want to be ready to try that case. But the clients, and it's not the downfalls of the system is the time. It's hurry up and wait.
Right.
You have to be very patient. And there's some things, we push the issue as hard as we can. And some things are out of our control. I mentioned 30 days, that's a month. And if you have all these 30-day deadlines, they can add up. So we'll absolutely push the issue, but some things are out of our hands. Sometimes time can benefit us, but 90% of the time it's going to help the defense.
Right.
They want to wear you down as the injured party. And, you just got to, we have your back, you're in good hands, and, trust the process, and that'll be it.
Yeah. Well, thank you both for chatting about this today and educating folks and me. Justin, where should people go if they kind of want to learn more?
Always, you can go to our website, justiceslovely.com. You can find me on TikTok. I am still not dancing, but Randy's trying to get me to dance.
It's a work in progress.
Yeah, anywhere you consume social media, we're there. But of course, and if you just want to call and talk about it, call and talk to me or JP, just set an appointment.
Perfect. Well, thank you so much for watching the Carolina Justice Report today. We will see you next time.
When life gets ugly, justice is love.